Hello, ladies and gentlemen. My name is Alex DeFreitas. I'm an attorney here in Houston, Texas. I've been practicing for over 10 years now. A lot older than I look, I guess. And I'm a former Harris County prosecutor. Today I want to discuss with you what happens to your license should you refuse to take the breath test, refuse to take the blood test, or should your blood test or breath test result come back as a .08 or above. In any of those situations, Texas DPS is going to try to suspend your license. For your first DWI, should you refuse to take the breath test or refuse to take the blood test, they're going to try to suspend your license for about 180 days. Now, should you have a result that comes back off the breath test or a result that comes back off the blood test as above a .08, they're going to try to suspend your license for 90 days. Okay? Now, if their suspension goes through, you will then automatically want to get your attorney to apply for a restricted driver's license, otherwise known as an occupational driver's license. That license can last for about 12 hours a day, although different courts have different rules and regulations for how long they will give that driver's license. Some won't give it on every day over the weekend. Some will only give it for 2 hours in the morning and 2 hours in the day. Some will give you a driver's log, allowing you to drive where and when you want to, as long as you provide the information in the log and keep the log constantly on you. Some will give you a fixed time, 7 a.m. to 7 p.m. It really does depend on the court and what their regulations are with regard to giving out occupational driver's licenses. At this time, you'll also need to get what's called an SR22 form from an insurance company to go ahead and help out with your to go ahead and provide to the court. You'll also have to provide the court with a copy of your driving record. In some courts, the DAs do this for you. In other courts, you have to do it yourself. It's not really that expensive. However, there is a means, just so you understand, for you to drive to work and get back and forth and so forth to taking care of your kids as necessary. Okay? Now, the bigger question, though, is what are you going to do with regard to that license suspension? Are you just going to let it happen? Quite frankly, you don't have to. You have 15 days from the date of receipt of what's called a temporary license in generic terms to go ahead and make a challenge of your license suspension. Now, the temporary license is going to be given to you usually by the arresting officer on the day that you got arrested, should you refuse the breath test or the blood test, or should your breath test result had come back above a .08. You usually do not receive a temporary license if you volunteer to take the blood test on the date of your arrest. The reason being is that your blood test in Texas is not going to be available for 3 months to 6 months at least. As such, they're not going to know whether or not your blood level is over .08 or not. Now, once you've gone ahead and received this temporary license, which only lasts for 40 days, I would highly suggest that you read it, or once you get home from jail, I would highly suggest that you read the temporary license and read whatever other paperwork you are handed. You'll notice that you have basically 3 different distinct ways to go ahead and challenge for your license suspension. One is to go ahead and make a phone call into a number that's provided. Another is to go ahead and send a fax off, once again, to a number that you can find. And another is to check and go ahead and to check online and go ahead and make the request as well. Now, all these processes can be handled by an attorney for you to ensure that the ALR hearing is requested timely and is requested correctly. However, you can, just so that you know, do it for yourself. As such, for that reason, I provide that service to all of my clients for free. Now, the ALR hearing, then, once it is requested, kind of, to put it in simplest terms, puts off DPS's ability to suspend your license. In other words, DPS cannot suspend your license until one of 2 things basically happens. The hearing actually happens and occurs, or number 2, the hearing actually happens and occurs and the judge rules against you. Or number 2, the hearing is waived by you, which does happen in certain cases. If the hearing's waived or the judge rules against you, then DPS can proceed with the suspension of your license. However, at an ALR hearing, an experienced attorney is going to try to present arguments in your favor to go ahead and try to save your driver's license. They're going to question whether or not the police officer had probable cause to stop you. For example, if you were just weaving in and out of your lane one time, or just weaving within your lane just once, that may not be sufficient probable cause for the officer to have pulled you over. If the officer doesn't have sufficient probable cause to pull you over, that's going to basically not only help your ALR case, but also your overall criminal case as well. You took the breath test, was the machine working, and so forth. If you took the blood test, did they follow proper procedure in taking the blood, as the blood been maintained, and so forth. There are several different arguments that can be presented by an experienced attorney at the ALR hearing in your stead. The biggest thing that they're going to do, though, is subpoena the officer down there, and that's going to be the investigating officer, as well as maybe the breath test operator and so forth, and perhaps the toxicologist that was involved as well. The reason why you want to do that is because not only might it help with your ability to fight your license suspension, but it may also help you with regard to your underlying criminal case. The ALR hearing can provide you with the opportunity to get that first crack at the officer or other member of the state's investigation squad, whether it be the toxicologist or what have you. It provides you with that first crack to see what it is that they know, what it is that they actually did in the investigation, and whether or not they have enough knowledge, experience, and observation to actually go forth and testify that they believe that you were driving while intoxicated in support of their allegations. And remember, just because you're arrested for a DWI does not mean that you're guilty of a DWI. It is just an allegation, and the state has to prove it. So if you have that opportunity to, before trial, go ahead and start investigating what they know, what their experience is, it's an opportunity that you should take. Okay, now, with regard to it, if you miss those 15 days, you're done. Your license is going to be suspended, and you can move over into getting the occupational. You also missed out on that opportunity to do a little early investigation into, the individuals that are going to be testifying against you in terms of the officer and so forth, toxicologist and so forth. There is one other issue that I do want to address that does come up with some confusion sometimes, which I guess is a cheeky way of saying it, but there is the issue with what is called the portable breath test, or PBT. Okay, the PBT, or portable breath test, if you took it, is the test that they administer to you outside of the cop car, or right then and there at the scene of the incident, or the scene where you were pulled over. Okay, the portable breath test, or PBT for short, is not admissible in a court of law. Okay, and the portable breath test in and of itself does not count as the breath test for you to refuse. So, for example, if you took the portable breath test but then refused the breath test, the Intoxilyzer 5000 machine, the bigger machine that's utilized usually at the station, at the police station, then you are still considered to have refused the breath test. Okay? So you still need to go ahead and make that request to go ahead and save your driver's license, or give yourself the opportunity to challenge your license suspension. Now, having said those things, if there are any other questions that you have on this topic, I want you to go ahead and check the contact page. You can give a call into the office or send us an email if you're currently facing a DWI case and these are issues that concern you. Once again, I just want to go ahead and strongly recommend that you contact an attorney immediately if you've been arrested for DWI, because there are deadlines that are coming up. This deadline is not the only, the 15-day deadline is not the only one that could affect your case. And number two, I highly have to recommend that no matter what you do not handle your ALR hearing alone or without an attorney. The reason being is that most attorneys will recommend or instruct that you do not show at your ALR hearing. because at that ALR hearing, which is considered an administrative procedure, not a criminal procedure, you will lose the right, that constitutional right to remain silent. And quite frankly, the constitutional right to remain silent may be one of the strongest tools that you have in your defense. Just because nervousness and so forth when you're testifying can hurt your case. And that Texas DPS lawyer will call you up to testify in the ALR hearing. And a smart prosecutor will go ahead and request the record from the ALR hearing and use whatever you stated at the ALR hearing against you at your criminal case, should you get to that level. Well, ladies and gentlemen, I want to thank you for clicking on the video. I hope this has been informative for you. And like I said, if you're facing a GWI right now, please do not hesitate. Go ahead and shoot us an email or call in so that we can do what we can to help you with that situation as soon as possible. Thank you for your time, and you have a great day.